forth with the restraining order and enter a plea and then set a future court date so that we could try to deal with the substance of your case, okay?
Yes, Your Honor, and that's my concern is this proper? Because the only two options I have is the governor's warrant, where this would have to be validated in that process through the governor's warrant.
If we don't go through with this, then the warrant issues, which I don't think you want a warrant.
And that's what I was just explaining. The process of a warrant being validated by the governor of my state is that this has to be validated. So my concern is this validated before we go forward? Because the merits of the case have not been argued at all. And so is this valid? Is this process that we're doing right here, is this valid? Being that this was family court, so why is this not contempt of court as opposed to a criminal protection order? It says a criminal protection order is when somebody's arrested, there's a crime committed, and they do that to protect the witness. None of that happened. There's no criminal history here. This was an order put in place by family court, so why is this not contempt of court as opposed to a CPO?
Okay. Those are all questions that you can ask your lawyer after this proceeding. I'm not going to get involved. I'm not going to get involved in a debate with you, sir.
Yes, sir.
Either you're going to agree to accept the restraining order by email and confirm that you've received it, and if you don't do that, then I'll issue a warrant and you can come to court and be here in court and take care of it.
Well, that would be determined by the governor of the state that I'm in and the governor of the state of California.
I have no idea what you're talking about.
The governor's warrant.
Okay.
The extradition process. But what I'm asking is, can there be a little bit of clarification, Your Honor, because there's things that have gone on before this. I'm just for my caution, because I don't want to be signed this, agree to this, not knowing anything, and then still be penalized by the people that I'm speaking of. That's my concern. Is that is the literature airtight, so that it's not abused? That is my concern. I'm not calling you into question. I'm not here to be difficult, but I hope you can see that I've done my best to comply, but yet still here I am. So I'm apprehensive for a good reason. It's not like just to be difficult. It's because I'm concerned that this may be abused. So are you telling me that if I agree to this now, that an attorney we can iron this out later on? Because I have spoke to a private attorney and they said that this is not proper, that this is putting the cart before the horse, and that's the only reason why I asked. I did speak to a paid attorney and they said that this is being swapped out. This actual penal code is being swapped out for another, which would be the proper one to be in place. So by me committing to this, am I then not acknowledging that? It's concerning, Your Honor.
You don't have to agree to this restraining order, sir. It's going to be issued. The only question right now is because you disobeyed the court order and did not come to court today and personally appear. I'm trying to accommodate your concerns to have you served in the way that we're talking about. Now, I think that you probably have been properly served, but it's not according to the letter of the law because you're not here personally in court. And so what I'm asking is, do you want to agree to acknowledge that you've been served with the restraining order, and then we'll set a future court date?
Yes, Your Honor.
And if you don't want to do that,
yes, Your Honor,
that's fine. I'll issue the arrest warrant.
Yes, Your Honor.
Yes, what?
Yes, I'm accepting and acknowledging the request, Your Honor.
Okay. Now, there's one more thing that I want to do. I'm just relying on your representation that you're somewhere out of state.
Yes, Your Honor.
And I'm giving you a big break by allowing you to disregard the previous court order. And so I'm going to have the court clerk swear you in, put you under oath, and have you testify about where you actually are. Okay?
Yes, Your Honor.
All right, Madam Clerk, would you please swear in Mr. Ayala?
Anaya, Your Honor.
Anaya. Thank you.
Yes, Your Honor.
Do you solemnly state, under penalty of perjury, that the testimony you're about to give before the court in this matter is the truth, the whole truth, and nothing but the truth?
I do.
Okay. Sir, where are you located right now?
Virginia, Your Honor. Commonwealth of Virginia.
Okay. And I did look back in the file. Your addresses when you were cited for these offenses was on Rimrock Drive in Napa.
Yes,
Have
Your
you
Honor.
moved your permanent residence to Virginia?
Yes, Your Honor.
And how have you done that?
I've established myself in the state with the Veterans Administration, with the state of Virginia. I'm a voter here. I have mail. I have a lease. The only thing, if I stayed in California, I'd be homeless because I don't know where to go, you know.
Okay. All right.
May I just may the record reflect, though, Your Honor, that
Before you do that,
Okay.
do either of the attorneys have any questions to ask of Mr. Anaya about his residency and location?
No, Your Honor, I would just ask the court, while the defendant is under oath, that he is acknowledging and receiving of the criminal protective order.
Okay, and sir, did you receive the criminal protective order by email that I read to you on the record earlier?
Yes, Your Honor.
Okay, and you understand all of its terms?
To the best of my ability, Your Honor. Like I don't have the legal acumen.
Right. So you agree that you have been served with the papers?
I was emailed the document, and if that's what you're saying, and then
Okay. All right.
may I say something, Your Honor? May the record
Just let me finish with
Okay.
Ms. Noga. Was there anything else you wanted to say on that point?
No, Your Honor, but someone is chatting in the chat box. I had mentioned to the court earlier that I have heard the defendant apparently is talking about the situation on social media. Under, I believe it's 136.2, I do have concerns about coercion or witness intimidation if the defendant is going around and saying the alleged victim's name or discussing the situation. So I would ask the court to order the defendant to not discuss this on a podcast or any way for it to be publicized, because I do think that that does pose a risk to the alleged victim.
Your Honor, it's all public information. I didn't say the individual's name. An independent journalist under the constitutionally protected rights to freedom of press did their own research, and that's my issue, Your Honor. Is do you see what she just did? That's what I was trying to tell you. Is they don't care about this other stuff. I'm as far away as possible. They just want to silence the narrative because of their concern, and so that's how this all started. Was a violation of freedom of speech and the 14th Amendment, but. Me doing an interview with the media correspondent is not.
The order says in number 9 that there shall be no dissuading victim or witness. The defendant must not attempt to or actually prevent or dissuade any victim or witness from attending a hearing, testifying, or making a report to any law enforcement agency or person. It doesn't prohibit Mr. Anaya from talking about the case to other people. So,
It was a media correspondent, Your Honor. They interviewed
Mr.
me.
Anaya,
This is
let's
national
just
news.
one thing at a time.
I understand. I just want you to know, Your Honor, I won't do that. I'm not. That's not what I'm here for. I was
yeah,
just.
well, it sure doesn't help your case if you're doing that. I am deeming Mr. Anaya served with a criminal protective order that he's knowingly accepted and acknowledged receipt. And let's proceed with setting another court date or dealing. Oh, we need a plea entered today.
May I just state this to reflect the record, Your Honor, that Honorable Young had set this up for me. I wasn't trying to deviate from the court, but Honorable Young, there's a recording of it. He said for this to do this to get a public defender so that the public defender
Mr. Anaya.
could stand in my stead. I just don't
All
want.
right, sir, I'm gonna have to mute you if you don't let your lawyer talk, okay?
Your Honor, I would ask to set the plea setting over one more time since Mr. Anaya has requested to, or shown an interest in getting a private attorney, and because of that, I would just ask to set this for another plea setting. My suggestion would be December 18th. It's in about a month.
What would the plea be, Your Honor?
What?
A plea for what, Your Honor?
If you're to enter a not guilty or guilty plea.
And no arguing the merits of the case or the motion to set aside?
Not at this point. If you're intending to get another lawyer, I think that Ms. Barron's suggestion is a good idea. Once you enter a plea, then certain deadlines start kicking in, and you can waive those deadlines, but if you're going to get another lawyer, that lawyer will probably want this period of time to look into your case.
And a month is what?
The suggestion was, yes, a month on December 18th.
And there's a multitude of other. They had me in court like 7 times in a week period, 6 times in a week, Your Honor, because there is that adjacent family matter. This charge is before the Court of Appeals. It's on appeal. So it's like I'm having to do a pro se appellate brief. It's in federal court. Like, so there's an injunction going forward. It's like, there's a lot. So may there be more time, because that's what really bogs down, is being a pro se litigant and doing all this.
No, there cannot be any more time. Then I think a month is a reasonable period for you to get a lawyer. You may have other pending matters, but this case also has the right to proceed in a timely fashion.
Understood. I was just thinking for read a motion. Okay.
All right.
Yes, sir.
So, I'll continue this to December 18th for entry of plea and appearance of counsel. If you're getting another lawyer, you need to get one who will appear on the 18th. That will be at 9 a.m. in Department 3. You are ordered to appear. If you have a lawyer who agrees to appear on your behalf, then you can appear by Zoom.
Yes, Your Honor.
Okay? All right.
Thank you.
Are there any other issues?
No, Your Honor. Thank you.
All right, thank you. Goodbye.
Bye, Your Honor.